take care of that.
It's a mess.
It was,
I
in
tried.
hindsight, it was pretty convoluted.
All right, you're Carly Davis and Carly Hoosier, and this is 24 DCCR 1385 and 25 DCCR 1237. And so their state has, we were going to be here on reviewing bond conditions, correct? And then the state has filed a motion to increase the bond.
Yes, Judge.
And is that in both of the cases or just that
In
one?
both cases, Judge.
Let me pull this up. I know I took a look at it last week, but.
This one's Judge.
And so we've got both of these cases are driving while intoxicated, third or more. The first offense date is from May 6th of 2023. The second from February 10th of 2025. Give me just a second here. Well, it's working, it's just working slow. So I've got some history with regard to prescriptions. Some of it's obviously very hard to read, but it looks like prescriptions for alprazolam and something called D-amphetamine. Okay. Can't tell the date. One of them specifically says no refills. I can't read the dates on these.
We can get better photos, Judge. She had had that prescription for,
All right, it shows it expires October of this October 31st for the,
Judge, I had a number of questions about those photos myself. I mean, I'm not necessarily, well, I guess I am questioning the validity. This doctor that allegedly prescribed it, this Rajan Desai, there's either an Austin address or a Millburn, Texas address for this doctor. When I looked him up through the Texas Medical Board, and I'm just a little curious about.
so where do you go to the doctor? Where's this doctor from?
From Beaumont, and I do a telemed every month except for 3 months. I go to his office now. I have an appointment with him today.
Today?
Yes, ma'am.
Where specifically?
Telemed today.
Oh,
Yes.
well, here's what I think I'm going to do based on the nature of what these medications are and the history. Well, are you driving?
No.
Okay, I don't know if I already did, but a condition of your bond is going to be, as of today, that you are not allowed to drive any vehicle ever, period. Okay, so if you're caught driving, obviously you'll be right back in jail without, probably without a bond. Mr. Coleman, other than a no driving, is there any other?
No, Judge, I just would like to reiterate, and we put it in our motion, and it sounds like the court's read the motion, but, she's got 4 previous DWIs, Judge, and in addition, she picked up this latest DWI while out on bond for a DWI.
Right.
Judge. And that along with the positive drug test, I think the public safety, the community safety demands some additional assurances.
And Judge, our argument would be that the DWI itself is for the medications. She's been on these medications for,
Well, it doesn't matter if you're on medication and you're
Right.
taking too much medication, then that's a problem.
sure,
So you can be on these medications and not be
Also, the failure of the drug test was for these medications.
Right, I understand that. My biggest concern is the fact that if the medications are not being taken properly or too much of the medications, then that's a larger concern with the safety, and I completely understand and agree with Mr. Coleman on that. How'd you get here today? Here's what I want you to do, what I'm going to order you to do. I'm going to order that at your appointment, I'm requiring you to find out and with your doctor, get a prescription for something that is non-narcotic. So something that is not going to cause these issues if in fact our concern is that you are misusing or overusing these medications, then there's other medications that you can take. You need to talk to him today. I want you on your way to be off of both of these medications and on something that would not lead to the issues that you're having. Does that make sense? You need to get that information from him, find out what he can prescribe. I want those to Ms. DeLage, and I want her to get those to me. That is a condition of your bond at this point. If you don't do that today at that appointment and get that information to her, then I'm going to, what I'll do today is not rule on Mr. Coleman's motion. So that motion to raise your bond is still out there. And if you don't get this information and you don't get this done today, then your bond will likely be raised and you'll be in jail. Do you understand? All right.
My only question is, the medication to get off of it abruptly can cause.
I understand that. I'm not saying you have to get off of it abruptly. I'm saying I want the plan and how you're going to do it, what it's going to be reduced to, what it's going to take its place, whatever it is. I want that. You need to tell him that you have been ordered to get off the medications, but obviously that needs to be done in a medical way, but I want whatever that plan is and how you're going to do that, and I want that to Ms. DeLay so she can get it to me tomorrow. Okay? All right, y'all are free to go.
Thank you, Your Honor.
Okay, thank you. See,
Diamond Jane.
Mr. Floyd? Is Mr. Floyd here? Mr. Choate, good morning. Good morning, Mr. Choate. This is Richard Afong Wade, 23-41318. Mr. Hoffpower, good morning. Good morning. You're Richard Afong Wade? And Mr. Afong-Wade's case is set for trial to begin with jury selection next Monday. Again, what is everyone's announcement?
Unfortunately, we had to file a motion for continuance. Mr. Floyd had to have a partial knee replacement last Wednesday. He's under doctor's orders not to sit or stand for long periods of time. And so we had to file a motion for continuance. So I guess our announcement is not very much.
I got the message, Judge. I don't have an issue. I mean, I can't. He's got a medical condition.
Sure. Is there a timeline on that?
So in the next, I think he's got to follow up in 3 weeks, and then they'll reassess what he's allowed to do, right? Because like right now, he's still like at home.
Sure.
So,
Okay, so I'm going to reset the case to the next trial docket to give them plenty of time. Obviously, you guys know this was going to be the number one probably. It's really going to be up there next time. So as far as age goes, I'm going to set it, and if I need to protect everybody, I can do protection orders from our other courts if you need that as well, because it'll be time to get it way past time next time.
yes, Judge.
Tell him I hope he gets better, and we'll see y'all the next trial docket.
Thank you, Judge.
You're
We
free to go.
appreciate it.
Thank you, Judge.
Mr. Franklin, you've got Ray No, 2 cases. Morning.
Good morning, Your Honor.
Good morning, sir. You're Ray No.
Yes, ma'am.
And in cause number 25 DCCR 0386 and 0387, Mr. No is charged with intoxication manslaughter and the other driving while intoxicated with a child under 15. And what is the announcement?
We are ready to proceed to trial by jury, Your Honor.
Okay, have y'all done a rejection? So what I'll hold it while y'all do. On the tablet, there's a plea bargain rejection.
Okay.
If y'all will get that signed with whatever has been offered that you're rejecting, and then I'll go over consequences, options, all of that, and then we'll get it on the trial docket.
Understood, Your Honor.
Okay.
Get that filed.
Yes, sir, thank you. I'll hold it while y'all get that taken care of. Is Dontrell Scott here? Mr. Scott, Mr. Johnson called earlier. He is not going to be able to be here. He's ill. I'm going to reset your case. You're free to go. Just stay in touch with Mr. Johnson in his office, and they'll let you know when you need to be back. Thank you, sir. Mr. Kelly?
Yes.
You've got Adam Moe.
He's present. Good morning.
Good morning. Good morning, you're Adam Moe? Okay, so we're here because Mr. Moe is on probation
Yes.
for I did a different type thing where Mr. Moe went and did some time on some of his cases
That's correct.
in prison, got out and is now on probation. Apparently, there are some potential issues with regard to where he's living that weren't issues with parole, but are issues with probation. Is that correct?
It sounds like they may be issues with probation.
Okay.
That's kind of why our original emergency motion had a strange title, because we didn't know what else to call this.
Sure.
Other than in an effort to make sure that he is doing everything correctly. I think our mission on that was, let's get in front of the court and make sure this is being done correctly.
So what's the issue, potentially?
Adam's parents, Jody and Chris Moe, who the court may remember, and they're present again today, while Adam was incarcerated, went to a number of links with the folks from parole to make sure that any home that Adam was going to live in upon his release and beginning the out of prison portion of probation and parole, because he's on parole too.
Correct.
That their home where he was going to live was in compliance.
Right. Parole's approved it.
Parole has approved it.
So where are we?
If the court doesn't mind, I'd rather not say the address.
No, I don't need that. I just need to know what the issue is with
The
probation.
issue is, we are at 574 feet from a church that has a playground attached to it. And I don't want to speak for probation at all, but condition, I think it's 33, it isn't vague, but it's neither inclusive nor exhaustive. So I don't know exactly what the conversation was that probation had with Adam the day that he reported immediately upon his release from prison a couple weeks ago. And I don't believe that the conversation was, hey, you can't live there. It was, this is kind of an issue. So our position is a lot of effort was made.
So what's the issue?
Excuse me, so his condition number 33 says that he's not to be within 1,000 feet of places where children commonly gather. So
Right.
it's not limited to that list. And so I believe it's the 574 feet from the church with the playground attached is the issue.
Okay. I'm looking at the order now. Mr. Hoffpower, any strong feelings one way or the other?
Judge, we'll leave it to discretion of the court. I understand what probation is worried about.
Sure.
Set them up to fail. I do understand that's unique with parole and probation, two different entities, but
Well, and the
I don't want him
offenses
violated.
were possession of child pornography.
correct.
There weren't any allegations of
There were 10,
assaults or anything like that?
correct,
Okay.
just 10 charges of possession. And 5, we put 5, got penitentiary and 5 with probation.
Right. Is there a GPS at this point?
No,
He hasn't had his initial, actually, the assignment is tomorrow. He just did intake and, correct me if I'm
Sure.
wrong, he just did.
No, and I appreciate being proactive, and that is good. We don't want to be in here the first month because there's a violation, which technically that would be a there's no doubt that it's not vague. That would for sure be a
No,
violation.
in my reading too, on the geography of this thing, Judge, is that if Adam were to make, I'm gonna call it a left turn if I've got the map correct in my head. If he were even to turn incorrectly down the main street where this house is, that would be a parole violation. So our position is that parole's assessment here, and I know the numbers are what they are, but that it covers both issues. So it's not like there's some kind of leeway to go even closer to that facility. He isn't going that way. He cannot, or he's in violation of what's been set up for him.
Judge, Ms. Roach says if he lived there when he sentenced him, he's grandfathered.
He's not, though. They specifically moved to
Okay,
thank you, though.
yes.
Miss Roach is watching to make sure, because if you were living somewhere already, there's kind of a grandfathered in, but they specifically moved to try to make it better, and,
Yes, ma'am.
okay. Well, here's what I'll do. I will allow a modification of number 33. But I want it to somehow, some type of addendum or attachment that's very specific, because this isn't going to be a exception for all, only for this specific. So I will need probably the address of that church, so that in the orders, it says that you can be within 574 feet of that specific place. 33 stays the same for everywhere else. So it can be 33 can read like it does, and then you can add with the exception of that one place. Also, at least for, I would say, 6 months or so, or depending on how probation feels once he gets going, and if he's following all the rules and treatment and things like that with the LSOTP and all of that stuff, then I want a GPS monitoring device on at least for a minimum of 6 months to make sure that the rules are being followed, that he's going the right way, and there's not any issues. And that way, once we're all more comfortable with how things are going now that he's out of prison, then I'm okay with getting rid of that once you're okay with that, if he's following through with treatment and everything like that. Make sense? Okay?
Just one question. I think there's not school issue.
It's not the school issue, it's just the church.
The church. Yeah, the church with the, so I want that, that's the only exception, and the exception is the 574. So like you said, turn the other way, don't get any closer than what you're saying. That way there won't be an issue with it being any closer than what you're saying at any times that it would show up on that GPS. Make sense? Okay?
Yes.
All right, thanks. Y'all are free to go. No, ma'am. Mr. Burbank, Renisha Chason. Mr. Chason tested negative for everything, so that's good. Thank you. Yes, thank you. I need your signature, though. All right, ma'am, you're Renisha Chason, and will she waive the formal reading of the indictment?
She will, Your Honor.
And again, we're just gonna get a plea on the new indictment, reset the MTRP case, and come back and see where we are with the pre-sentence report. Is that correct?
That's correct.
Okay. That goes with that also.
Judge, just to refresh the court's recollection, the co-defendant in this case, who is the, in my opinion, much more culpable defendant has already pled the TDC time.
Okay, thank you. Ms. Chason, in cause number 24, DCCR 2351, you're charged with the second-degree felony offense of injury to a child, and that's from July 19th of 2024. And how do you plead to that charge? I'm sorry? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand? And it looks like the agreement that you've made is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, states one.
It's admitted. Is there any evidence that Ms. Chason's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, but I'm going to reset your case so that the probation department can do a pre-sentence report. And if that can include an update also on the probation case where the motion's filed, so I can have all that information as well, and then we will come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see y'all back at sentencing.
Would the court consider allowing her to remove the drug patch? It's costing some money that she doesn't have.
Not until sentencing. We're going to keep it on until sentencing. Make sure you keep it on and keep it updated, and then if everything goes well,
When do I come?
it's about 5 or 6 weeks. Okay?
Maybe you excuse me.
Yes, thank you. Mr. Franklin, on Mr. No,
Yes, Your Honor.
all right, again, sir, you are Ray No.
Yes, ma'am.
And Mr. No, in cause number, hold on, let me get it pulled up. Cause number 25, DCCR 0386, you're charged with a second-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 0387, you're charged with the state jail felony offense of driving while intoxicated with a child under 15. In the same offense date of December 11th of 2024. And in that case, if you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
I have here on the tablet in each of your cases plea bargain rejections that you've signed with your attorney that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. In the intoxication manslaughter case, that offers for 18 years in prison. And then in the
I think I'm marked too long on
Should be
it.
2
It should be.
2 years state jail?
Yeah.
No, okay,
Yeah.
all right. Okay, if I make that modification?
absolutely,
Thank you.
Judge.
So in the other, well,
And if you can't read my writing, I'm
nope,
happy
that's
to-
okay. I'm obviously don't know how to erase because now I'm just making marks all over this document. I feel like I know how to. Okay, so, good grief. It is a Monday. All right, so in that state jail felony case, the offer is for 2 years. In the state jail prison, it would run concurrently with the other case. You have every right to reject these offers and have both of your cases set for trial. I just want to understand, make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am, I understand.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am, I do.
Okay, we'll get that done. And Mr. Coleman, is there any reason to believe that these offers would change? Is there any evidence that you're waiting on or anything like that?
No, no.
So I do want to make sure you understand that after today, Mr. No, I won't accept this plea agreement. If you change your mind and want to enter a plea of guilty that would be to something different or open to the court, unless there's new evidence that your attorney or the district attorney gets or finds out about between now and then. Make sense?
Yes, ma'am.
Okay, we'll see y'all at trial. We'll get it placed on the trial docket.
Thank you, Your Honor.
Thank you.
Your Honor, may I be excused?
Yes, sir, thank you. Yeah. See, Mr. Valles?
Yes, Your Honor.
Good morning, sir. On Crystal Calvillo?
Yes, Your Honor.
Calvillo? I'm sure I'm saying that wrong. Good morning, sir. Good morning, ma'am. You're Crystal Calvillo?
Yes, ma'am.
And Ms. Calvillo was previously in court and cause number 24 DCCR 2456 entered a plea of guilty to the state jail felony offense of theft of property. I've received that pre-sentence report. Any additions or corrections to that report?
No, Your Honor.
No, for the state.
All right, ma'am, I'm going to find that you entered your plea of guilty previously freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years.
Yes, ma'am.
You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the felony conviction on your record. And at the end of that probation period, if you successfully complete it, the case is actually dismissed and you will never have that felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and then you could be sentenced anywhere in the range of punishment, which is up to 2 years at a state jail prison. Do you understand? And there's no restitution, correct? Okay. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation, she's going to call you up to her desk when she's ready to go over all of your paperwork.
Thank you, ma'am.
Good luck to you, ma'am. Thank you, sir.
Thank you, Your Honor.
Ms. Holmes? You've got a sentencing on Cameron Gutierrez? Sentencing on Cameron Gutierrez. Good morning. Good morning. Are you Cameron Gutierrez?
Yes, ma'am.
And Mr. Gutierrez was previously in court and entered a plea of guilty to evading arrest or detention with the use of a vehicle in cause number 25 DCCR 0325. I've received that pre-sentence report. Have you both had an opportunity to review it?
Yes, Your Honor.
Yes, sir.
Any additions or
And
corrections?
from the defense.
No, for the state.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation.
Yes, ma'am.
If you do that, this is a great opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end of the probation period, the case will be dismissed and you'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, which would make you a convicted felon, and sentenced to prison for anywhere in that punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Thank you. Mr. Kelly. I lost Mr. Kelly. Mr. Kelly. Mr. Mitchell, you've got John Van Wright,
Present.
2 cases.
Yes, Judge.
Good morning.
Good morning, how you doing?
Good, how are you?
Oh, I can't complain.
It's Monday. Nobody would listen if we complain anyway, right?
Drove in for Fort Worth to be here, though.
That's right. Good morning, sir. You are John Van Wright, and this is 24 DCCR 2485 and 15 23582. What is the announcement?
As far as the MTRP, it would be not true, Judge.
Okay,
Philip, you're not.
I think we'll just, prove up the MTRP first, Judge.
okay, so let's do this then. Let me get that pulled up. We'll go through that entire motion, and then we'll get an updated report and set it for sentencing. Mr. Van Wright, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. And will he waive the formal reading of the motion?
Yes, Judge.
Mr. Van Wright, in cause number 15-23582, I have a motion to revoke your community supervision. Shows that you were placed on probation July 28th of 2020 for the 3rd-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 10-year term in prison, but it was probated for 6 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the offense of injury to a child, elderly, or disabled individual November 14th of 2024. And is that true or not true? All right, did you enter your plea of not true to count 1 freely and voluntarily? All right, then I'm going to enter that plea of not true on that count. I'm going to reset the case for sentencing hearing. About how long do you anticipate?
I want to know more than
About an hour or so, so we could do it maybe at the end of a docket. So we'll set it for 11, probably on a Monday, just at the end of one of these dockets, unless I can find a time when we're not in trial on another week.
Okay.
And that'll give y'all time for any
you can just
evidence.
let me know, or have Kelly or somebody let me know so we can get witnesses here.
We'll do it. She'll be back tomorrow, and we'll get that set in the next couple of days. If I can get an updated pre-sentence report, that would be great as well. And then we'll see y'all back at sentencing. All
Sounds
right?
good, Judge.
Thank you. We need to get his print, please. Yeah, make a note for Kelly, though, that it needs a hearing about 1 hour. We probably can do it on a Monday unless we find another day.
Yeah, I think this was Judge.
Yes, thank you. Mr. Rennick, you have a sentencing on Alexandria Bledsoe. Sentencing on Alexandria Bledsoe. Good, how are you doing? Thank you. Good morning, are you Alexandria Bledsoe? And this is 25 DCCR 0004. Ms. Bledsoe was previously in court and entered a plea of guilty to the state jail felony offense of abandoning or endangering a child with intent to return. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, sir.
Any additions or
Only
corrections?
one minor thing my client would bring up. The name of her employer was Cigna, correct, or Sigma? Cigna, it was listed as Sigma, and she was just worried that that might be an
Okay,
issue. I told her not to worry
Don't
about
worry
it,
about
but
that.
she wanted to bring it to the court's attention.
okay, thank you very much. Anything else?
So, Your Honor.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include completing an intensive parenting class. If you haven't already done that through CPS, there's going to be something through probation that you're going to need to do, obviously. If you do everything that you're supposed to on this probation and follow all of the rules and conditions, then this is an excellent opportunity because you do not have a felony conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to the state jail prison for up to 2 years. Do you understand? Okay, obviously, I would like to think that this was a huge wake-up call because this could have been very, very bad. And so take care of your child, take care of the classes, make sure you make all of the right decisions when it comes to that, and you shouldn't have any issue. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Thank you.
1-minute voiceover script ****. Judge Raquel West delivered a powerful warning in a tense courtroom hearing involving a repeat DWI defendant. Prosecutors argued that the defendant had multiple prior intoxicated driving offenses and had allegedly committed another DWI while already out on bond. After reviewing the case, the judge focused on public safety and imposed a strict new bond condition: no driving under any circumstances. The judge warned that if the defendant was caught driving again, she could be returned to jail and face stricter bond conditions. The court also addressed concerns about prescription medications and ordered the defendant to work with her doctor on a medically supervised plan to transition to safer treatment if appropriate. The judge emphasized that the goal was to protect both the defendant and the community while ensuring any medication changes were handled safely. The hearing ended with a clear message: obey every court order, follow the medical plan, and avoid any further violations or risk losing your freedom. It was another reminder that repeat impaired driving cases can lead to increasingly serious legal consequences.